Good morning, this is your Kelso Report for Monday, November 28th, and I'm your host, Clark Kelso. Well, the top news of the day. The NBA owners and the players appear to have reached a settlement. As you will recall, the players disbanded their union a few weeks ago and hired David Boies to file an antitrust lawsuit against the owners. But David's remarks to the press on the day of that filing suggested that the pathway to resolution had to be negotiation and not litigation. I think David knew from his recent experience representing the NFL on the other side of the labor table that the players' legal position was not particularly strong. It was unlikely a court would grant any immediate relief to the plaintiffs, and most likely, as in the NFL case, the court simply would decide that this was still a labor matter that should have been pushed back to the bargaining table. So it was no real surprise when the lawyers for the owners and players got the ball rolling last week with preliminary conversations that ripened into negotiations between the principals. Although a lot of details still need to be worked out, it appears that the players had to give up quite a bit of money to close the deal. According to the early reports, the guarantee of basketball-related income to the players will be no higher than 51%, compared to the 57% the players received under the prior deal. That is a swing of about $240 million annually, which adds up to billions over the course of the 10-year deal. More details will spill out over the next week, and the players now need to reform their union to vote on the deal. I think it's a pretty good guess that the owners will approve. In this case, it does look like the reality of the players' litigation position may have brought some reality to their negotiation position. Now that actually works only if counsel has a realistic sense of the likelihood of success for such litigation, because it can often happen that litigation between business parties drives them further apart. Kudos and credit here to David Boies, who undoubtedly gave some pretty blunt advice to the players about their prospects if they continued to pursue litigation instead of cutting a deal. Well, our featured case for the day involves government law and sovereign immunity. Congress has waived the United States' sovereign immunity for only certain clearly specified causes of action, and the court's role in these cases is to follow the rules set by Congress. If there's a clear waiver, the courts are open to plaintiffs with claims against the government. If there is no clear waiver, the courthouse doors are to remain shut, even when it seems unfair to someone who has been injured as a result of government employee misconduct. These can be hard cases for courts that are used to doing justice for each and every plaintiff. A good example is the Ninth Circuit's decision in Levin v. United States. After unsuccessful cataract surgery, the plaintiff filed an action against the United States government and his United States Navy surgeon, alleging both malpractice and battery. The plaintiff was unable to find an expert willing to testify in support of the malpractice claim, and so it was dismissed by the court pursuant to the government's motion for summary judgment. The battery claim was based on an allegation that the plaintiff twice tried to orally withdraw his prior written consent to the procedure, but he was operated on notwithstanding his attempts to withdraw his consent. The court dismissed the battery claim because the Federal Tort Claims Act expressly preserves sovereign immunity against battery claims, and it found nothing in the Gonzales Act to change that conclusion. The issue on appeal was whether the so-called Gonzales Act waived sovereign immunity with respect to plaintiff's battery claim. Now, the Gonzales Act was enacted in 1976 in reaction to rising concerns about the costs of medical malpractice insurance incurred by government doctors and the resulting impact on employee morale and recruitment. In response, Congress enacted the Gonzales Act, which provides an immunity from personal liability for military doctors by designating remedies against the United States under the Federal Tort Claims Act, not lawsuits against individual health care providers, as the exclusive means of recovery for plaintiffs alleging malpractice. One particular provision of the Gonzales Act, Section 1089E, provides as follows. For purposes of this section, The Federal Tort Claims Act's preservation of immunity against battery claims shall not apply to any cause of action arising out of a negligent or wrongful act or omission in the performance of medical, dental, or related health care functions, close quote. The plaintiff argued that this section actually has the effect of waiving sovereign immunity against battery claims by negating the FTCA's preservation of sovereign immunity against battery. Well, after close examination, the Ninth Circuit rejected this interpretation, even while acknowledging that it appears to be a viable first reading of the statute. The court explained that there was an important difference between waiving the government's immunity to damage claims, which is what the plaintiff argued, and a slightly narrower interpretation that, solely for purposes of substituting in the government for the military's doctors, made sure that the substitution applied not only to the negligent malpractice claim that was covered by the Federal Tort Claims Act, but also to the possibility of a battery claim related to medical malpractice. As the court explained, the purpose of Section 1089E was not to serve as a waiver of sovereign immunity, but instead as an expression of personal immunity from battery claims brought against military personnel. It is fair to ask why Congress would have enacted the language in Subdivision E, since under the Federal Tort Claims Act, the government's immunity for battery is preserved. The answer given by the Ninth Circuit is that, absent Subdivision E, Congress would have been worried that, quote, clever tort plaintiffs, close quote, could use government's immunity from battery under the Federal Tort Claims Act to argue to sympathetic courts that while no remedy against the United States for battery exists, a battery remedy must still exist against the individual military health care provider. And Subdivision E forecloses this argument. I think the Ninth Circuit probably has the right decision here. While the court's conclusion may seem backwards and harsh, that is probably because we are generally not used to thinking in terms of sovereign immunity and the rule of statutory interpretation that waivers of sovereign immunity must be clearly expressed by Congress. Instead, we are trained as lawyers to think that there should be liability under common law principles unless there is some special reason not to impose liability. In sovereign immunity, this reasoning is flipped, and there is no liability unless there is a statute that affirmatively allows it. And whatever one might say about Section 1089E's purpose and language, you can't really say that it clearly waives sovereign immunity. As a result, the plaintiff's claims for battery was dismissed on sovereign immunity grounds for lack of subject matter jurisdiction. And now on to our one-liners. First to the area of criminal sentencing. In United States v. Rudd, the Ninth Circuit reversed the district court's imposition of a special probation condition that prohibits the defendant, who was convicted of traveling to a foreign country and engaging in illicit sexual conduct, in his case sexual conduct with school-age boys, from residing within 2,000 feet of schoolyards, parks, public swimming pools, and the like. The probation report recommended that he be prohibited from residing within direct view of schoolyards, parks, and so on. But the district court expanded the restriction to within 2,000 feet of such facilities. The Ninth Circuit held the district committed procedural error by failing to explain why it imposed the 2,000-foot residency requirement, rather than the much less restrictive condition specified in the plea agreement. The reasons for the 2,000-foot rule were neither explained by the court nor apparent from the record, and the Ninth Circuit remanded so the district court could either explain its reasons or enter a different order. Frankly, I don't envy the district court in this case. I doubt there is any clear basis for drawing the line at any particular point, whether it be just not in direct view, 1,000 feet, 2,000 feet, 3,000 feet. It all has the feeling of rather arbitrary line drawing. One advantage of a definite radius, such as 2,000 feet, over not in direct view, is that it is probably much easier to administer. You just look at a map, and you will know whether the 2,000-foot rule has been violated. The same is not true of a not in direct view limitation. Good luck to the district court. Next, arbitration. In Sachs v. Dietrich, the Ninth Circuit held that 2 arbitrators were entitled to arbitral immunity in a suit brought by a person who the arbitrators had disqualified from representing their client in arbitration. The plaintiff, who was not a lawyer, had entered into an agreement to represent someone in a securities arbitration proceeding to be administered by the Financial Industry Regulatory Authority. According to the applicable rules, a person could be represented by a non-attorney unless that person was currently suspended or barred from the securities industry. And in fact, the plaintiff had been barred from the securities industry in 1991. The plaintiff filed an action alleging intentional and negligent interference with contract. While applying the clear rules of the authority, the district court held the arbitrators were immune from suit pursuant to the doctrine of arbitral immunity, which provides that arbitrators are immune from civil liability for acts within their jurisdiction arising out of their arbitral functions. The Ninth Circuit here easily affirmed. Next, in the area of remedies and contempt. In Malik v. Kaushik, the 2nd District reversed the Superior Court's imposition of a $1.7 million restitution order as a sanction for indirect contempt, finding that the Superior Court denied due process by entering the order without prior notice or a meaningful opportunity to be heard. The court had previously ordered that a company allegedly operated by the defendant as a cover for a fraudulent scheme be taken over and run by a receiver. The receiver ultimately filed an ex parte application for the issuance of an order to show cause for a contempt, but that application did not refer to any request for restitution. After a 3-week bench trial, the court found the defendant guilty of 10 of 29 contempt charges and sentenced him to a total of 50 days in jail and imposed a $10,000 fine, the maximum amount of jail time and fines the trial court could impose. At the end of the sentencing hearing, the receiver requested that the trial court consider any other available remedies to require the defendant to return the money he diverted from the receivership. Based on evidence presented during the hearing, the court ultimately entered an order compelling the defendant to pay $1.7 million to the receivership as restitution for monies diverted from the company to the defendant. The 2nd District reversed, since the defendant was given no notice that a restitution order might be litigated as part of the contempt hearing, and after the issue was raised at the very end of the hearing, the defendant was given no opportunity to be heard on it. Next, we deal with the class action case in Davis-Miller v. Automobile Club of Southern California. The 2nd District affirmed the Superior Court's denial of a class certification motion in a case alleging that the AAA had falsely advertised member discounts as part of its battery replacement program, and, because of the payment incentives in the program, caused technicians to recommend unnecessary replacements of batteries. The evidence developed for the class certification motion showed that the program actually was only sporadically and infrequently advertised. Most class members did not recall seeing any advertisements, and when individual members were informed of the possibility of a small member discount, they testified they would have purchased the battery with or without the discount. The evidence also strongly suggested that technicians actually were not replacing large numbers of batteries unnecessarily, and that to determine whether a battery was unnecessarily replaced would require gathering specific information about each replaced battery. The 2nd District agreed that in these circumstances the plaintiffs failed to demonstrate the commonality of facts and legal issues required for class certification. Next, we have a family law case. In re ZK, the 3rd District held that the juvenile court violated the natural mother's constitutional rights by terminating her parental rights in favor of a plan of adoption, even though it had not made any finding that it would be detrimental to the minor to be placed in the mother's custody. 5 years after her husband had disappeared with her son from Las Vegas, the child's mother, who had moved back home to Ohio, discovered over the internet that the child was in Tehama County. She immediately contacted the Tehama County Department of Social Services to request custody, but because of her financial circumstances, she could not arrange for an immediate reunion with the minor, and dependency proceedings had already progressed to the stage of a hearing to select a permanent plan for the child. which was going to be adoption by the current foster mother. The momentum of the proceedings apparently resulted in finalizing the order terminating parental rights and approving adoption, even though the court made no finding whatsoever that termination of parental rights would be in the best interests of the minor. Appellate court reversed. Finally, in the area of environmental law, in Pfeiffer v. City of Sunnyvale, the 6th District affirmed the City of Sunnyvale's certification of an EIR and approval of a project to expand a medical campus. 2 neighbors had challenged the approval by petition for writ of mandate, claiming that the project was inconsistent with the city's general plan, the EIR used an incorrect traffic baseline for analysis, and the EIR used a hypothetical background traffic noise level. The 6th District affirmed the trial court's rejection of all of these claims, finding that the project was not out of conformity with the general plan, and the EIR adequately discussed and analyzed all of the issues raised by the petitioners. And that's it for today's Kelso Report. Have a great day in the law.